Good morning, everyone. I am going to be getting used to this little clicker, so hopefully that will go well. I want to just talk a little bit about some current issues in copyright, and I'll start by giving a little background to make sure we're all on the same page. Then there's kind of a new twist I want to talk about, and then maybe a little refresher on the kind of notice and takedown procedures. So the U.S. Constitution isn't something you probably talk about too often at these meetings, and it's probably getting a little bit more press than usual these days, but it does provide the source of Congress's power to regulate copyright. So that's Article 1, Section 8, the Copyright Clause, and I just reproduced it for you right there. So copyright, as you may know, protects creative property, and I also listed the types of property on this slide. So one thing that's really important, I think, from our perspective here is that the law provides for the protection of original works of authorship. They have to be fixed in a tangible medium, but that can be, a piece of paper, or it can be a device from which the work can be perceived, reproduced, etc. So it can be with the aid of a machine or device, and that's obviously pretty important to this group. As you know, copyright, the concept, predates the internet by quite a bit. So when the law was overhauled in 1976, I think it's safe to say that digital issues kind of brought up by the internet were not really a consideration. So in 1998, Congress enacted the Digital Millennium Copyright Act, and one result of that was that law limits online infringement liability for internet service providers. And that was needed because use of copyrighted materials on the internet may violate, in fact, does violate likely some of the exclusive rights of copyright owners, such as the right to reproduce works, the right to display, the right to make copies. And so the Digital Millennium Copyright Act, DMCA, helps us to limit exposure for service providers. So service providers are defined within the Act as entity offering transmission, routing, providing connections, etc., or a provider of online services or network access, or the operator of facilities, therefore. So there could be several layers of service providers involved, even within one allegation of infringement. So the DMCA rules, the safe harbor rules, are codified at 17 U.S. Code Section 512. And I have listed the main criteria here. The first one is that you need to designate an agent to receive notifications of claimed infringement, and that's kind of where the news section of this comes in. And then the service provider has to act expeditiously to remove or disable access to the infringing material once you are made aware by the owner. Then adopt, implement and inform subscribers of a policy about repeat infringement. And last, accommodate and not interfere with standard technical measures used to identify or protect copyrighted works. And those are all statutory requirements. So designating an agent is something that has been available since the DMCA came in, but unfortunately, very oddly, their original choice was to have you fill out a piece of paper and either send it or fax it, which seems counterintuitive given that we're dealing with everything digital. So what they finally did as of December 1st, 2016, was to replace the old paper system. So now you can do this online. And I think this is really a great development for the industry because it's obviously going to be more efficient. And it also provides, I think, a better lookup function for people that are wanting to go ahead and use the information. So the online system does replace the old paper system, and it allows you to use a lawyer or another representative to complete that registration function. So the information that needs to be provided is just basic contact information that's listed there. And you just go to the online system, and I've got the login page for you later on here. And you can also, as I said, use a lawyer or another type of representative to do it. So that is helpful if you don't want to do it yourself. You can also, if you have multiple subsidiaries, all of those can be managed under one account. The second part of designating an agent is that you have to make that person's name and contact information available on your website. And usually that's included either in the legal section of the website where you have all your legal documents, or maybe in the footer. I've put the link there for you to the login page for that designated agent website. You can also you can designate an employee, such as maybe a customer service manager or something like that, or you could also designate a third party to act as your designated agent. I have clients that use me as their designated agent, and so then I receive communications on their behalf and forward them on. And as I said, a single account can be used to manage designated agents for multiple service providers, so that if you do have subsidiaries, you can manage them all in one place. The other nice thing is that if you have alternate names, there used to be kind of more of a fee for that. Now they've reduced the fee. I imagine there's plenty of efficiency that they're realizing at the Copyright Office with this procedure. So the new fee is $6 for a designation, and there's no fee for alternate names. So an alternate name would be if you have, for example, if you're ABC Hosting Corporation, but you are doing business as ABC Hosting or Super Hosting or any other names that you use or that the public would know, so that they can search under those names within the catalog and be able to find you and provide that safe harbor function. And this is just a copy of the login page, so you can kind of see what it looks like. So one of the other requirements is what we call the notice and takedown procedure, so that if you have your designation of agent filed with the Copyright Office, your organization receives a notice through the designated agent, then this is the procedure that would be followed. So I've listed on this page the elements that are required to be included in the copyright infringement notice. So it has to be signed, it has to identify the work that is claimed to be infringed, it has to identify the material that is claimed to be infringing, and then it has to provide you, the service provider, with information that allows you to find that infringing material. Then it has to state that the complainant has a good faith belief that the use complained of is unauthorized, and it has to state that the information is accurate, etc. So those are just kind of legalistic requirements, but basically they have to tell you what the information is that they want taken down. And once you receive that, then you have to respond expeditiously to remove or disable access to the material and take reasonable steps to notify your customer or subscriber. Now, reasonably expeditious is not defined within the statute, so I think there is some flexibility there, and basically you have to, not drag your feet on it. So with my clients, typically we just send it right out to the customer, and what we usually do is offer the customer an opportunity to take down the material themselves. Now, 9 times out of 10, what we get back is an email from the customer saying, "Oh my God, I'm so sorry, I had no idea that I wasn't supposed to do that. It's already been taken down." And if they do not respond, then we will just take the material down for them. So then the customer has the opportunity to provide what we call a counter notification. And sometimes they do that. The ones that don't say, "Oh my God, I'm so sorry," sometimes we'll send a counter notification saying, "I have the perfect right to do this, and here's why." And then here is a list of the elements that they have to provide you for that in order for it to be a valid counter notice. It has to be signed, has to identify the material that's been removed or disabled, and then they have to state they have a good faith belief that there's a mistake or that there's some other reason that the material can't be removed, along with subscriber's name and address, and a statement that the subscriber consents to jurisdiction in the federal court for that district. And if you do receive a valid counter notice, then you need to put the material back and stop disabling access. Then there's this requirement to have a policy for repeat infringers. Again, this is another term that's not well defined within the statute, so we don't know, is a repeat infringer necessarily someone who has been accused twice of infringement? Is the accusation of infringement or the allegation sufficient? Do they have to be proven within a court to be an infringer? But I think that the key here is to have a standard policy that you implement and enforce so that you treat essentially all customers the same. It's not just an arbitrary process. So I would suggest that you provide notice to the customer just as you would for a regular notice and takedown procedure, and then provide the customer with a meaningful opportunity to provide a counter notice. You could also consider implementing a system for trusted customers, and these could be customers, for example, that have not had an allegation of infringement within the past year, or some other criteria that you decide and then that you enforce across the board as a standard policy. And then, of course, not terminating the account until there's been a meaningful opportunity to respond. Standard technical measures. So if you recall, one of the other criteria was not to basically circumvent standard technical measures used by copyright owners to identify or protect copyrighted works. And the criteria are listed here. These are measures that have been developed pursuant to a broad consensus of copyright owners and service providers, and things that are available to any person on reasonable and non-discriminatory terms, and don't impose substantial costs on service providers or networks. And so one thing that's important about this is that so far we don't have a consensus. That broad consensus of copyright owners and service providers doesn't exist. So it's really, at this point, we don't have any standard technical measures that you have to worry about. And those are the main points that I wanted to cover, just as I said, kind of a refresher, and then provide the new information about the Copyright Office's new procedure for designating an agent. Does anybody have any questions? Okay. Oh, waiting.
Matt Petak, Yahoo. I'm just curious, can you clarify, if you don't actually pay the $6 registration fee and go to the website and register, is there a penalty for that? Is this a voluntary we'd like you to, or is there power of law behind not registering?
Well, not registering at all may take the form of removing you from the safe harbor protections. So in other words, you might have liability for a customer's infringement. If you have registered under the old paper system, there is a grace period through December of this year now, December of 2017. And part of the motivation for doing the updated process was just that people sent in their piece of paper 20 years ago, and then the guy named on that piece of paper left, and then it was never updated, and so they realized that a lot of these were out of date, and I think that really having the electronic system will encourage people to keep it updated. The fee is lower, it's just easier all around. So there isn't a monetary penalty per se, but you might get slapped with an infringement lawsuit later.
That penalty may come in the form of a much bigger lawsuit than you expected.
Correct.
Got it. Thank you.
Correct. Any other questions? Okay, thank you very much, and thank you again to the program committee for the opportunity to speak today.